Good evening. I'm Sarah Watson, the Executive Director of Looking for Lincoln in the Abraham Lincoln National Heritage Area. Welcome to tonight's show, Water Under the Bridge, Abraham Lincoln and the Effie Afton Case. The Effie Afton Case, Hurd versus Rock Island Bridge Company, is one of Lincoln's most famous cases, pitting the established river interests of St. Louis versus the burgeoning railroad interests of Chicago. The case has traditionally emphasized Lincoln's support of the railroad and new technologies. Recent scholarship shows that might not be the case. John Lupton and Dr. Samuel Wheeler from the Illinois Supreme Court Historic Preservation Commission are here to discuss what happened when the Effie Afton crashed into the first railroad bridge to span the Mississippi River at Rock Island. John Lupton is the executive director, John, is the executive director of the Illinois Supreme Court Historic Preservation Commission, and Samuel Wheeler is the director of history programs of the Illinois Supreme Court Historic Preservation Commission. For more information about Looking for Lincoln's conversations, you can visit our Looking for Lincoln Facebook page. Now, it's my pleasure to introduce John and Sam.
Thanks, Sarah. Thank you, Heather, for helping get the program together today. Thank you for good partnership that we enjoy with Looking for Lincoln. This is our, by my calculations, the fourth time that we have gotten to join Looking for Lincoln to talk in detail about a Lincoln legal case. The first time we gave sort of a thumbnail sketch of Abraham Lincoln's appellate practice before the Illinois Supreme Court. We gave a program on Lincoln's most controversial case, the Matson slave trial, in which Lincoln was on the wrong side of history in that case. And most recently, we covered Lincoln's most celebrated murder case, the Duff Armstrong case, in which Lincoln saved a family friend from the gallows. Today, we're going to talk about the Effie Afton case. A recent book that I highly recommend if you're intrigued by the story that we're going to tell you today is by Brian McGinty, and it's called Lincoln's Greatest Case, The River, the Bridge, and the Making of America. Is the Effie Afton case Lincoln's greatest case? It might not be his most well-known case. It's on that short list of Lincoln's most significant cases. But McGinty makes the argument that this civil case had huge consequences for the future of the nation, and the role that Lincoln played in this case was consequential to the outcome. So you can be the judge if we agree with McGinty as we talk about Effie Afton tonight. So at the outset, I think I'll just lay out the context. I'll tell you what happened, and it'll give us a base of which to really analyze what happened in this case. So here we go. In April 1856, the Chicago and Rock Island Railroad built a bridge across the Mississippi River. It linked Rock Island, Illinois with Davenport, Iowa. And as Sarah mentioned at the outset, it was the first bridge to span the Mississippi River that could accommodate railroad traffic. That's a remarkable moment. Riverboat interests weren't necessarily happy about the arrival of this bridge. The bridge would accommodate railroad traffic, and that would probably take money out of their pockets, the pockets of the steamboat operators along the Mississippi, who for the previous 30 years had a real monopoly on moving people and goods by the river. So the world was changing, and not everybody was eager to embrace innovation that this bridge represented. So just 2 weeks after the bridge was completed, on May 6th, 1856, a steamboat named the Effie Afton, named after a children's author. The Effie Afton was a new boat. It was a fast boat. It crashed into this bridge in the middle of the one of the piers that was in the Mississippi River. It crashed into one of these piers. The Effie Afton caught fire. The bridge itself caught fire. The boat was a loss, as well as the cargo that was on board. So what happens next? The owners of the Effie Afton filed suit in federal court, not state court. Why? The owners of the Effie Afton were from Ohio, and the Rock Island Bridge Company that built this bridge was an Illinois company. So the litigants were from two different states, and the damages were going to total more than $500. So that would be a case that the federal courts would hear. In September 1857, the case begins in the United States Circuit Court in Chicago with Supreme Court Justice John McClain presiding. He was a former Whig who'd been a legitimate contender for the Republican nomination in 1856. By the way, he was one of only two dissenting voices earlier in the year when the Dred Scott decision was turned out. The lead attorney for the Effie Afton was a man named Hezekiah Weed. The lead attorney for the Rock Island Bridge Company was Norman Judd, a New Yorker who since the 1830s had made his home in Chicago representing railroad interests. He had been a Democrat, but he split with the party and eventually becomes the chairman of the Republican Party in the state of Illinois. The Effie Afton case, or more formally, Hurd et al. Versus the Rock Island Bridge Company, began in September 1857. This is a huge trial. Before arguments were made in the courtroom, more than 1,000 pages of depositions had been accumulated. A lot of legwork, and a lot is going to be at stake in this trial. The owners of the Effie Afton, they lost their ship, they lost their cargo that was on board. They're seeking more than $900,000 in damages. That is a huge number. So in terms of damages, there is a lot at stake. But John, I thought I might throw it to you here and think about what else is at stake. There is something to be said that this case could set sort of a larger precedent that we need to be aware of at the outset.
Right. And actually, and I'm going to go back in time just a little bit because I wanted to mention, excuse me, the Wheeling Bridge case. So, a lot of legal issues, don't just appear out of whole cloth. So the Effie Afton case is actually a pretty similar case to the Wheeling Bridge case, which occurred in Wheeling. Now West Virginia, is then Virginia. But the Wheeling Bridge opened up in 1849, crossing the Ohio River. And it was a suspension bridge, so it was pretty high off of the river. But once the bridge was built, a lot of the river interests opposed it. And so there was a case to basically declare the bridge to be a public nuisance and have it torn down. And interestingly, one of the lawyers who was involved on the side of the river interests was a Pennsylvania lawyer by the name of Edwin Stanton, who we know later on became Lincoln's Secretary of War. The case goes to the U.S. Supreme Court. The Supreme Court declares it to be an obstruction to navigation, and they actually say that they should raise it to be 111 feet off of the low water mark. So then that's when the bridge interests got involved. They had legislation passed in 1852 that said this is actually an important road because it carries the mail. So it's almost like a federal route. And then it goes to the U.S. Supreme Court again, and the U.S. Supreme Court says that, okay, since this is a federal post route, basically steamships have to adjust their smokestacks in order to go under the bridge. So the bridge remained. So that's kind of a precursor to the Effie Afton case and maybe foreshadowing what's about to happen.
So we have a lot at stake. It's not just necessarily about the Effie Afton and their damages, but there are river interests. In St. Louis, in this case, there's organizations that are fighting the idea of these bridges that will accommodate rail traffic that will span the Mississippi River. And their argument is those bridges constitute an obstruction in the river, and they're a nuisance. And perhaps we should use this case to try to set a precedent to discourage the building of these bridges across the Mississippi. That would be a huge accomplishment to make that those river interests would be quite happy with. So that's sort of the context that's taking place here. We said that Norman Judd was the lead attorney for the Rock Island Bridge Company. He did the legwork. He's involved in accumulating those 1,000 pages of depositions from witnesses, etc., before this trial goes to court. But before the trial begins, he added another lawyer to his legal team, and that's Abraham Lincoln. Abraham Lincoln was not from Chicago, right? He's still here in Central Illinois in 1857. And John, I'll throw this out there. We don't have a definitive answer to this, but let's kick this idea around. Why did Norman Judd pull Abraham Lincoln's name and want him to play a role in this case? What do you think?
Yeah, it's a great question. And, we obviously don't know the answer. But just to speculate on a few things, I mean, we always associate Lincoln with like the 8th Judicial Circuit or even his practice before the Illinois Supreme Court. But, we really don't talk about his federal practice a lot. And one of the reasons why we don't is that most of the federal records were destroyed in the 1871 fire. So we don't have the body of material with Lincoln's federal cases like we do with a lot of his state circuit cases and certainly his Illinois Supreme Court cases. But this was kind of a, again, getting into the evolution of Abraham Lincoln, the lawyer. He's got a lot of things that are on his side that would make him a good attorney, really on either side of this case. He was known as, someone who was especially knowledgeable about the river. He grew up, obviously he did flatboats down to New Orleans a couple of times. He actually even had a patent for a device that could rescue boats from sandbars. So, I mean, he had some knowledge about how rivers actually work. Lincoln was also, mechanically inclined. He loved geometry. He read Euclid while he was traveling the circuit, and engineering. And in this case, he talks a lot about, the angles of the currents and things like that. So it really plays to his strength as a mechanical type attorney. He liked patent cases also. And then even from a political perspective, this is a time, this is 1857. So Lincoln is really kind of, he has risen in the legal profession quite a bit. He's been practicing for 20 years now. So he's got this established legal career, and he's being brought in as like a hired gun, to a lot of these cases. I think that's certainly the case with some other cases that were going on at this time.
The Armstrong murder case.
The Armstrong murder case. And actually even the Matson case. Lincoln wasn't the lead attorney in either of those, but he's brought in as the guy who can kind of batting cleanup and can hit the home run and knock all the RBIs in. But he's also kind of a political rising star. So in 1856, he received votes for to be vice president of the United States. He ended up not getting that, but politically, his star is really rising. And this is obviously a year before he ends up running for the U.S. Senate, and the nascent Republican Party. Lincoln is really establishing himself in Illinois as the leader of that state party. So there's a lot of reasons why he could be brought in. And I'm not saying that any one of those reasons is the right answer, but it could be a combination of all of them.
Yeah, that's great. Okay, so now we get to the courtroom. September 8th, 1857, the trial begins. The first day is devoted to jury selection. They select 12 white males to the jury. Most of them live in Chicago or the Chicago area. There's a couple exceptions, but for the most part, they're from the northern part of the state. The plaintiffs are going to lay out their case. Hezekiah Weed is the lead attorney. He presents his case for about a week. This isn't one of those trials we've talked about in the past that gets settled in one day. That Duff Armstrong murder case, they did it all in a day. This isn't going to be like that. This case, I think, goes on for about 2 weeks. Weed lays out his case for the first week. He's going to read witness depositions. He's going to call witnesses to the stand. In all, he calls about 80 different witnesses to the stand. And what sort of testimony are they offering? His case is going to hinge on the idea that this bridge was an obstruction in the Mississippi River. It was built in a bad spot. There is the natural currents that are taking place in the Mississippi River by putting these piers in the places they put them in. It really wreaks havoc with the currents, creating sort of these different conditions that are very hard to navigate for even the most experienced pilots. What are other things that he's trying to demonstrate with his witnesses, John?
Yeah, it's really just demonstrating. To describe this, the bridge has 8 piers. 2 of them are on land, and then 6 are in the water. And then in the middle of the current is what's called the long pier. And the long pier is really like the principal issue in this case. And by long pier, what I mean by that is you have a pier that's basically just a column that's in the water. But the long pier is actually, and I don't remember what the size of it is, but say it's like 100 feet long. And that allows the turntable to actually turn, which then allows the river traffic to go through. And then you can close the turntable, which allows the railroad traffic to go over. But this long pier, the plaintiffs argue, was placed not parallel to the current. So that's their main objection, that if it had been placed parallel to the current, then maybe this bridge wouldn't be an obstruction. Or maybe they just needed to build a suspension bridge instead of a drawbridge type bridge. So that's kind of their main focus, is talking about this long pier and how it obstructs or it affects the current, or it's not parallel to the current. And that's what a lot of this testimony is about. These pilots, captains, workers on the boats who say, yeah, we tried to go through and we crashed into the pier, and then we crashed into the other pier. We had to lay up at St. Louis for 2 weeks to get repairs. So everyone, all of these witnesses are pretty much saying, yes, this bridge is an obstruction and must come down.
Yeah, in their case, they're trying to demonstrate as well how much care the owners of the Effie Afton took for this run. They talk about their usual captain had a lot of experience navigating the Mississippi River, particularly the lower Mississippi River from St. Louis to New Orleans. This particular run that the Effie Afton is trying to undertake is going to go from St. Louis all the way up to St. Paul, Minnesota. The pilot had never had much experience in making that northern run, and so they actually hire another pilot for this part of the trip, a man by the name of Nathaniel Parker, who gives some pretty colorful testimony. And I will say about that testimony, we talked about all the eyes that are on this case because it's significant. This is a really interesting case in the sense that there are 2 different reporters taking shorthand notes in the case. They're biased in their own mind. They're hearing the same things, but they're interpreting what they're hearing differently. So those notes are really interesting, but we get a real sense of what these witnesses are testifying to.
Yeah, this is only one of 3 cases where we have a complete trial transcript. And so, that makes it, pretty unique among the 5,000 Lincoln cases, is that we actually know what Lincoln was saying in the courtroom. And that's really valuable in learning how Lincoln presented himself in court.
Yeah, you get that sense. And then the last thing that I'll say about the case that they present, out of those 80 witnesses, what I found was really intriguing. They say that about 1,000 successful runs had taken place under this bridge by other boats. But they found that there were 7 boats that crashed into this bridge in the first 11 months of its existence. And they call those pilots up to the stand and they question them about the problems that they had navigating, the water under this bridge. Some of them talk about the bridge, the path that they have to go under is too narrow, and you get lots of hyperbole. This is the worst, constructed bridge, we've ever, had to navigate. So that's really the crux of the plaintiff's case. John, anything you want to add?
No, not really. Really just kind of moving on to the defense, so once the plaintiff side rests, then the defense gets their turn. And really, this was like after a week of testimony, like Sam said. So their testimony or their witnesses kind of begin on September 15th, and they end up calling a total of 30 witnesses. And, the main response for the defendant's side is really that the boat operators were negligent. So they point out how when the boats came up to the bridge, it was the water was kind of high. It was windy that day. So there were like 10 boats that were laid up and basically just waited there overnight to cross the bridge, or excuse me, to go under the bridge. And so the Effie Afton, is like very early in the morning, they kind of backed up out of their spot. They hit another boat, which kind of damaged their guardrails a little bit. And then another boat had taken off before them, but the Effie Afton was a pretty fast boat. So they passed this other boat and then made their move into the draw. And so the defense is saying that they were being reckless, that he didn't enter the draw where he was supposed to or how he was supposed to, because he was going too fast because he had just passed a boat. So that's kind of their main argument. But they're also talking about, they bring in engineers to, basically say, this is how we located this bridge. We used floats to, we floated them down the river and kind of see where the passages go. They also talked about the careful positioning of this long pier, because I was talking earlier about how the long pier is sort of the central problem with the plaintiffs. But the defendants are saying that the long pier was purposefully put at an angle to make the current on the Illinois side straighten out. But it creates more eddies on the Iowa side, which isn't used. The Illinois side is the one that's used. So they said if they had put the pier parallel with the current, it would create eddies on both sides of the pier, which would be a problem. So several of these engineers relayed that information. Someone even brought in a model of the bridge and the water to actually show the jury how it all came together. So, and interesting, there was one witness, a man we might have heard of before by the name of John Deere, since he lived in that area, in the Quad Cities area. He lives actually close to the bridge. He testified that the bridge isn't the problem. It's a bigger problem upriver where the Rock Island Rapids take place. That's more of an obstruction to the river traffic than the bridge. So his testimony wasn't, important to the entire case, but it's just interesting that John Deere himself testified at this case. So there had been 7 accidents, and the plaintiffs had talked to those, and they were on the stand. But the defense said that 900 other pilots were able to go through this draw with no problem, and that these 7 actually occurred, very close to when the bridge first opened. So it was basically just the pilots getting used to the fact that, how they need to go through the draw. So, and then the defense really ended their case by sharing some pretty powerful statistics, actually, that showed how the bridge, really was an incredible benefit. So in the 11 months that it had been in operation, there were 12,586 freight cars that had passed over the bridge that carried 125,000 tons of freight, and 74,000 passengers had passed over the bridge. So this is an impressive benefit to the economy, and really kind of demonstrated how this railroad traffic is important to transportation routes in the burgeoning United States.
So we've laid out both sides of the argument. The plaintiffs say they're owed damages for the loss of the Effie Afton and its cargo because the bridge is an obstruction to free and open travel of the Mississippi River. The people that built the railroad bridge should compensate them for their loss. They had messed up. They built this bridge in the wrong part of the channel. They built a bridge that was too narrow to pass through. Yes, only 7 boats were damaged, but didn't that illustrate that there was an obstruction nonetheless in the form of this bridge? And so the plaintiffs offer up that closing argument, and then it's time for the defense to give their closing argument. Another attorney makes the point about the negligence of the captain of the Effie Afton. John did a good job illustrating the problems with that fellow, that he had, as he was preparing to enter the draw, he backs out. He actually hits another boat. Does that sound like a guy who's taking, good care of this situation? As he's approaching the bridge, he actually engages in what they claim is a race with another boat, and that gets him to enter into this draw from the wrong angle, and he himself is to blame for this crash, and the railroad bridge should not be held liable. But the defense isn't done yet. They bring on the closer, and the closer in this case is Abraham Lincoln. Abraham Lincoln got brought onto this case to sort of listen to witness testimony, to share notes with his team about questions you could ask those witnesses. But this is the moment, after observing for 2 weeks, Lincoln is expected to give a compelling argument to those 12 members of the jury. Is this a role Lincoln is comfortable with, John? Do we see him operate this way in other cases as well?
Yeah, I mean, that's one of his strengths, is being able to talk to a jury. Lincoln sort of has that folksy, homespun way of speaking, and he can kind of bond with the jurors, more easily. And he would frequently tell jokes about how he's pitted against these educated lawyers who use all these big words, and they're not really talking to the jury. They're just kind of trying to lecture to them. So yeah, Lincoln has always kind of had this bond with juries, and that's helped him in a lot of cases. I'm not saying that it wins every single case for him, but it does give him a certain advantage over other attorneys who maybe speak down to juries, where Lincoln realizes that, hey, these are the guys who are deciding my case. And I do mean guys, because there were no women on juries at the time.
Yeah, he has a really good ability, I think, to synthesize 2 weeks worth of material that the jury has heard and sometimes nodded out from hearing. And Lincoln is able to synthesize that material, talk about the key important aspects of what they heard, and spin it in a sympathetic way to his side. He's able to form that bond with the jury. I think that's one of his real strengths as a lawyer. Couple of the points that he makes, I think, are interesting to point out. He suggests that this case might not entirely be just about the damages for the Effie Afton. As we talked about earlier, he talks about those river interests that are threatened by the idea of a railroad line cutting into their business, crossing the Mississippi River. But Lincoln talks to that jury about how important that rail traffic is. There are times in the year when the Mississippi River freezes, when it brings long hauls to a halt. And Lincoln reminds them that the railroads never stop. They can go in any sort of weather, just about. And he points to those statistics that the railroad bridge has done a remarkable job of moving people and material across vast distances. And that would be a terrible thing for the future of this country to lose if such a precedent were set. And Lincoln talks about, he's sympathetic to those river interests, of course. As John said, he has a lot of experience as a river boatman on those flat boats. He understands they're trying to run businesses too, but he talks about, we've got to strike a healthy balance between the rail traffic and river traffic in this case.
And not ironically, but interestingly, that's what Justice John McClain, who said the exact same thing in the Wheeling Bridge case 5 years earlier.
Very good. And so, of course, Lincoln's going to hammer home the point that railroad bridge is not an obstruction in the Mississippi River. He spins those statistics yet again, I think, is a really fascinating way. I think we already alluded to this, but out of those 7 crashes 1,000 boats made their way successfully underneath this bridge. 7 of them did crash. Lincoln is able to go back to the months in which those crashed, and he's able to show these pilots were just getting used to this bridge. Those crashes occurred in the first couple months once this bridge was out there. And he shows that pilots are getting more familiar with it. These crashes are becoming less and less. And so this won't be such a problem moving forward. And again, reiterates that this is pilot error that will lead to these crashes.
Yeah, I think that was probably Lincoln's most effective argument that he had in his closing arguments, that, the Effie Afton pilot was really negligent, not just, crash, bumping into the other boat and then trying to pass the other boat. But, Lincoln makes the point to the jury that, okay, so you come up to this bridge, you see that there's a bunch of other boats that are waiting for their turn. They're all waiting over until the next morning. So what do you do? So you're not piloting. So do you just go out, have a good time in Rock Island, have a night out? Or, as Lincoln is saying, did you, check out the bridge? Did you go to the bridge and examine it? Because this is your first time passing through this draw. So, are you looking at the currents? Are you looking at the draw and how everything is going through it? So he didn't do that. And I think that was a pretty effective argument that Lincoln had in his closing statement.
I thought that was an interesting argument as well. And here's one of the disputed points in the historiography of this case. Lincoln does say, that pilot should have gotten a skiff. He should have went up to that bridge. He should have watched the currents. He could have done a couple experiments to kind of figure out, how am I going to navigate my boat through this? Did Lincoln do that himself as he was preparing for this case? Did he visit the bridge? Did he do some tests on his own to try to become familiar with what he's going to have to try to argue? What do you think about that?
Yeah, there's some, like you said, there's some disagreements in the historiography about whether Lincoln made a trip to Rock Island to look at this. The evidence, I think, is pretty strong that, yes, Lincoln did go to Rock Island, and, it's possible that he had gotten up to Chicago and they took a train from Chicago to Rock Island. Lincoln spent a good day there interviewing some of the people who would end up being on the witness stand for his side. And then even, dropping some floats himself to look at it. We have a letter from Norman Judd, who was the principal attorney for the bridge side, basically is writing Lincoln saying, hey, I hope you got what you needed out of your trip to Rock Island. This letter is a transcription. It's not an original letter, so we don't know if it's actually written by Judd. So that's kind of where the question in the historiography comes up, whether he did. But I think it's pretty strong, especially if Lincoln is making that argument in his closing statement that, hey, the pilot should have gotten out and checked out things. He's actually doing that himself. Yeah. So, I think Lincoln probably maybe wouldn't have brought up that argument if he hadn't have gone to the bridge himself to check things out.
So we rest the case. Now we give it to the jury, and it's up to them to decide what's the outcome. Is the Effie Afton going to be compensated for their damages? How is this going to all work out? In this case, verdict required a unanimous jury, required everybody to decide along the same lines. By 9 o'clock, we get word on September 24th that the jury is deadlocked. They have voted in favor of the bridge 9-3. 9-3. So it's not a unanimous decision. What does this tell us, John?
Well, for all intents and purposes, it means that the bridge won the case. Because the idea was that, they wanted to get damages for the case and basically have the bridge declared to be an obstruction, which means it would have to come down. But because the jury was hung, that means the bridge could stand. And of course, actually, by the time of the trial, they had already rebuilt the bridge, and it was, it had quite a bit of traffic going over, as we talked about before. So the bridge was still operable. Which again is basically a victory for Lincoln's side, the bridge side.
Lincoln received, we think, $400 for his work in this case. when he receives his payment at the end of this case, he's done with the case. But that's not the end of the story. Norman Judd still stays with this case. It is, there's 3 or 4 attempts legally to get this thing back on the books. It also goes all the way to the United States Supreme Court at one point. Go ahead.
Yeah, actually, that case is actually kind of interesting to talk about because there's a St. Louis pilot who brings a case in the Iowa federal court. It's the Ward case, the Ward versus like the Iowa railroad, which built really half of the bridge. The Illinois built the other half of the bridge. So the Iowa federal court actually declares, and you didn't need a jury because this is a different kind of a trial. The Iowa court declares the bridge to be a nuisance and that they have to tear down the Iowa side of the bridge, but they could leave the Illinois side intact. They end up appealing that to the U.S. Supreme Court, and the U.S. Supreme Court basically says that, or overturns the lower court judgment, basically saying that, well, the draw is on the Illinois side. And so if there is an obstruction anywhere, it's on the Illinois side, not on the Iowa side. So it's dumb to tear down half a bridge. You can't do that. So the bridge remains standing. So that was some other litigation. One other little sort of interesting historical tidbit is that after this case, after the hung jury ended in the Effie Afton case, Hurd was still looking at some ways to perhaps continue this lawsuit. And so he wrote a letter to Stephen Douglas, of all people, saying, hey, I agree with you politically. You're the man. How would you like to be in my lawsuit? On my side, I can pay you a ton of money. Help me out here. And Douglas never responded to him. But it kind of, again, shows this hired gun mentality that I was talking about. I mean, Hurd's not hiring Douglas because of his legal acumen on, river cases and bridge cases. He's hiring because he's a U.S. senator and he's a big name. So having someone like Stephen Douglas on your side is definitely going to carry some weight. And Lincoln is actually getting into this same sort of stratosphere as Douglas, being hired as being brought into cases as a hired gun.
20 years into his law career, Lincoln has achieved that status. That's very interesting. So we've had all these other failed attempts to use the legal system to get this bridge out of the Mississippi River. And then finally somebody does the old method of he just tries to burn down the bridge. And that's largely unsuccessful. So what about that larger precedent? We were possibly worried at the outset of this legal case that a precedent could emerge that says that we can't have these bridges as obstructions in the Mississippi River. We can't use we can't span our railroads across the Mississippi River. Is that going to be a reality at the end of this case? No. Today, we are very familiar with bridges crossing the Mississippi River. I think there's more than 120 bridges today that span the Mississippi. McGinty's book does a really good job, John. I think, I don't know what you think on this, but I think he does a really good job of contextualizing this case. It's not just about this legal case. It has immense implications for the future of the nation. Mm-hmm. He brings in characters into this story that you normally wouldn't associate with this case, like Jefferson Davis. What Lincoln is doing in that closing argument, in addition to trying to win this case, he's articulating a vision for the future of the country as well. What do you think about that sort of McGinty's closing argument in this book about the larger implications, significance of this case?
Yeah, I thought he was very effective in saying that, as we've been talking about, this is the first railroad bridge to span the Mississippi River. So, we've got this accommodation of rail traffic. And, we have this, we're ideally hoping for this harmony between railroad traffic and river traffic. But you mentioned Jefferson Davis, which is, kind of a key point in all this, because Jefferson Davis was Secretary of War from 1853 to 1857. And so this was before the bridge was built, during the time the bridge was built, and they wanted to build this bridge. Jefferson Davis said, no, you can't build a bridge there because that's federal property, the Rock Island Arsenal. You can't build a bridge there. We end up having some lawsuits that saying, yeah, it's an abandoned federal property. Yes, you can build a railroad across it. But what Jefferson Davis is really objecting to is not so much the building of the bridge across the river, but building a bridge across the river in Rock Island, because Jefferson Davis wants a bridge built somewhere in Mississippi. Now, why would Jefferson Davis want a bridge built in Mississippi? That creates better expansion for the slave interests, to the west. So basically, Jefferson Davis is advocating for a transcontinental railroad as early as the 1850s, but he wants the southern route again, so you can take your slaves to West Texas, to New Mexico, to Arizona. And, one of the reasons he's involved in doing the Gadsden Purchase, which purchased that little southern area of New Mexico and Arizona, was to create more land for the slave interests to move out west. So that's kind of the big issue here is, Jefferson Davis, trying to create this transcontinental railroad on the south side. And who ends up creating the transcontinental railroad on the north side? Abraham Lincoln as president of the United States. So, Lincoln obviously realized that the railroad was important to the growth of the United States. And, so he acted upon this in creating the transcontinental railroad. But it does kind of bring another interesting point about Lincoln, the lawyer, I think, because this case is frequently used to show, Lincoln was a champion of the railroads. Lincoln would not have been involved on the other side of this case because he believed in the future of railroads and the growth of America and things like that. Well, that is true. But, again, Lincoln is an attorney. I think if Jacob Hurd had written to Lincoln and said, hey, will you be on my side? Lincoln would have said, yeah, I can argue.
No.
Yes, I can argue the river argument on this, which he actually did a few years earlier in the federal court on an issue on a bridge that crossed over at Peoria. So, Lincoln can argue both sides. But yes, this is one of those few instances where Lincoln's personal interests align with the side of a case that he's on.
Couldn't put it any better than that. That's excellent. So I enjoyed our diving into this one here, the Effie Afton case. I mentioned a couple times Brian McGinty's book, Lincoln's Greatest Case. Highly recommend it for anyone in the audience who wants to learn more about this. Heather, I think we are ready to see if the audience has any questions for us to try to handle on this one.
Well, okay, we'll get started. There are some questions, and I have a couple questions, so we'll just get started on the questions. Thank you both for sharing. It was very informative. I learned some things I didn't know, so that's always a good thing. All right, so here's your first question, and either of you can answer this. How many lawyers were on each side?
Yeah, it's a good question. There were 3 lawyers on each side. So on the Effie Afton side, Hurd side, there was Hezekiah Weed, who was from Peoria, Timothy Lincoln, who was from Cincinnati, and the other guy's name escapes me, Sam. Yeah,
you got me.
Yeah, there was a third guy who was also from Illinois, and then on the bridge side, it was Norman Judd, who was a former Democrat turned Republican, and Joseph Douglas, I think, who was from Chicago also, and Abraham Lincoln. So three on each side.
You had a Douglas and 2 Lincolns.
A Douglas and 2 Lincolns, yeah.
Man.
Wow.
Sounds like the beginning of a joke.
Yeah, it really does sound like the beginning of a joke. Also, for those who are watching, if you would like to type a question or ask a question, please type it in the chat, and I'll try to get through as many of them as possible in the time we have. I forgot to mention that before I asked my first question. So if you'd like to do that, we'd love to take your questions. Sam and John, I'm sure, would love that. But here's my question. So obviously you have the hung jury, and so then it kind of just works its way through. But were there any like repercussions? Like it felt like Lincoln's primary argument was it's the pilot's fault, right? So like today, if that were the case, you would think that there might be like a follow-up suit against the pilot. He might get sued in civil court or something. So do we know, did anything like that happen then? Did they not do personal liability like that? Like, I guess that's kind of my question.
Yeah, no, they didn't have any like personal liability against the Jacob Hurd, who was the captain. I mean, it is possible, I would think, that the bridge could have sued them, you know, for damages to the bridge. They ended up not. And actually, sort of an interesting footnote to the whole Jacob Hurd story. So he's trying to continue this suit. But in 1866, he's on a steamboat somewhere along like Tennessee or in the southern part of the country, and his steamship explodes, which is a common occurrence on these types of ships. And he's died, and his body is never found. He dies, and his body is never found. So that's sort of an unfortunate footnote to the Jacob Hurd story.
Yeah, that's very sad. Death by steamboat explosion.
Mm-hmm.
All right, so here's your next question. How many personal, and maybe we don't know this, but how much personal anecdotes did Lincoln add to his closing arguments? Like, do we know, did they keep track of like everything he said?
Yeah, so in this case, we said that there were two different stenographers that were reporting on this case. They did really good job of capturing witness testimony. However, the closing arguments, they summarized. They did not give verbatim closing arguments. So the easy answer is we don't know exactly what Lincoln said, but we do know things that he talked about. Generally speaking, in Lincoln's closing arguments, yeah, there was a lot of personal reminiscences, all sorts of metaphors to growing up in southern Indiana. And that was famous in the Duff Armstrong murder case that we covered last time. His closing argument, a huge part of his closing argument, was about his personal relationship with that family that I think was incredibly effective in bringing several jurors to tears. We look at that a little strangely today, but at the time, I don't think they viewed it as anything wrong with that.
Yeah, in this case, I think he was more, in the Hurd case, I think he was more technical oriented. You know, we do, like Sam said, we do see some his talking about his experiences as a flatboat captain earlier in the trial, but not so much in his closing statements. But like Sam said, it's just a summary, so we don't really have an exact verbatim copy of what he said during his closing statement.
Lincoln had such an interesting mind in this time period when he comes back from Congress and he sort of goes through that quasi-political retirement. He's working hard on the circuit, trying to rebuild his career. And I always thought one of the strange observations from this time is he's carrying around a book of Euclid's geometry with him. And I had to take geometry, and it's nothing that I did in my spare time for fun. But Lincoln, he loved it. And he liked working out the proofs. He also loved, the angles. And it was sort of how he used a lot of that in his conversation. And in this case, according to those summaries from his closing argument, he talked a lot about geometry, angles, and sort of that mechanical mind that emerges during this period with him.
All right. So here's the next question. You guys referenced, or John specifically referenced, the case about the bridge crossing the Ohio in Wheeling, Virginia, now currently West Virginia. How familiar, or if at all, would either the defense or the prosecution been with that case? Would that be something that Lincoln would have known about, been familiar with it? Not so much. I'm just curious because you've referenced it, but because of the geographical distance and different things at the time, was this something that was in lots of newspapers? I'm just I'm curious.
Yeah, this was a big case that happened in the early 1850s. So yes, both sides would have been familiar with this case, especially the plaintiff side probably would have been using it more because the bridge was declared to be an obstruction, but legislation was passed to kind of get around that. So it does have kind of a not the ending that, yes, this is an obstruction, the building or the bridge comes down. So obviously with a lot of law cases, it's kind of a nuanced answer to the question that's being asked. But yes, they would have known about it. But actually, they referred more to this. I briefly mentioned this Peoria case that Lincoln was involved with, where a boat hit a bridge on the Illinois River, damaging the bridge that crossed the Illinois River at Peoria. And it was an insurance case, actually. And like I said, Lincoln was on the side of the river interests. So they spent some time during the Effie Afton case talking about this Peoria bridge case. So in some respects, I think they were not in some respects, they were referring more to the Peoria bridge case than they were the Wheeling bridge case.
And is that because of Lincoln's connection to it, or because it was like, what was the outcome of that case?
That the bridge was not an obstruction. So that was the outcome of that case. But like I said, it was more insurance related, who was responsible for paying the insurance to the damaged boat. But yeah, like I said, Lincoln was on the river interest side in that case. But I think it was newer. It was only like maybe a year or so old. And John McLean, who was the judge in the Effie Afton case, was also the judge in the Peoria bridge case. So I think it was just more familiar to everyone in that courtroom than the Wheeling bridge case. So kind of what you were referring to, Heather, about the Ohio bridge case being or the Wheeling bridge case being 800 miles away, whereas the Peoria bridge case is just downriver.
Just downriver.
Yeah.
We're talking about cases that served as perhaps precedents, things that could be used in the courtroom. In this case, I think we all found it ironic as we were preparing for this discussion tonight on March 30th, earlier this year, just a few weeks ago. We had a crash on that Francis Scott Key Bridge in Baltimore. In that one, mechanical failure led to that collision. But wow, the past is never really the past, right? It creeps up and reminds us all the time that these issues are still incredibly relevant in the world around us.
Mm-hmm. Yeah, that's a great point.
Yeah, our rivers are still our transportation highways.
Yeah.
Yeah, I mean, you drive over the Illinois River, you drive over the Mississippi River, and you're always going to see a barge, it seems like.
And there's still trains that cross all those rivers, too. I mean, yes, we have cars now, and that's different for passenger travel, but, railroads and riverways in the United States are still a very important form of
air travel. You've got our ingenious interstate system. There's a diverse network out there.
Just to show you, too, how kind of important this case was in the balance. So the law license, if you're licensed as an Illinois attorney, it's got all this kind of fancy artwork on it. And in one of the corners is a railroad going over a bridge over the river, and you've got barges going under that bridge at the very same time. So you've got the Illinois law license basically showing this harmony between the railroad interests and the river interests. And the river is lined with shocks of wheat. So it's just, this beautiful pastoral image of, railroads and rivers getting along, singing Kumbaya.
Yeah. Yeah. Okay. So our next question, Lincoln, so you said that Lincoln was kind of brought in because of his experience with juries, right? That's why you guys, I mean, obviously you can't know exactly, but that's what you guys think of, because he was he could make complicated things relatable to juries. How about we say it that way? So in the exception of this case, what other cases was Lincoln in where he would have been brought in like this? Well, you guys mentioned the Almanac trial, but in addition to that, like, was this something that he frequently did? Because this is outside of, the 8th Judicial Circuit. So this is way outside of where Lincoln normally would have practiced. So.
Yeah, that's actually a good question, because, we often portray Lincoln as being the center character, and it's because it's Lincoln, of course, being the center character in every single lawsuit that he's involved in. He's not. Again, he's brought in this case, in the Armstrong case. Probably another really famous case where he was brought in as a hired gun is the famous Sandbar case, where this was when they straightened the Chicago River in the 1830s. It caused a whole bunch of accumulated land on the north side of this new pier. And then, since it was extremely valuable land, there were many, many, many lawsuits over that. And the case ended up going on for I think almost 15, 16 years. Lincoln was only brought into that case for just one of the trials, which is another one we have a trial transcript for, so we know what he's doing in that case. But again, just another example of Lincoln being a hired gun, and again, for the reasons that you mentioned, he's good in front of juries. He's becoming well-known politically and legally. And, he's just got this great rapport with juries, which helps him win some of these cases.
Those cases that we're referencing, they all happen around the same time.
Yeah.
Lincoln, he's been a lawyer for 20 years. As John said, he's achieved status in his profession, but he's also achieved such a rising star status as a politician, and we can't underestimate that. And so to bring him into these high profile cases right around this time, I think is really interesting. He ends up, he takes a different fork in his profession, in the sense that he becomes president of the United States, right? Had he not run for president, he would have sort of attained that next level in the legal profession, having that gravitas of that political, background that he has. But he's going to be a hired gun. Those fees are going to go up. He can come in, he can observe a week-long, 2-week-long case and knock it out of the park with a great closing argument. That was sort of that status that he's now arriving at late in his career.
And in the meantime, even though, yes, he's being a hired gun in a lot of these cases, he's still taking these $10 promissory note debt cases. So he's wearing both hats now, where he's brought in as the hired gun, but he's also still this everyday attorney collecting debts.
He's still traveling that circuit, and his contemporaries later on, they all mention it. They're just confused by that. Why is he subjecting himself to that lifestyle? He doesn't need to, right? But he loves it.
Mm-hmm.
All right. So here's another question, and then we're going to have to wrap it up. As you said, Lincoln had a way of talking to jurors. It may have been mentioned or unknown, but what was the setup of the jury as far as men, women, and age? And I think you already said that there were not female women jurors at the time.
Correct. Right. Women couldn't vote. Women really had no political standing. There were no women on juries. Actually, we didn't have women on juries until the 1920s, after they got the right to vote, because generally what was required for you to be a juror was that you had to be a voter. So women couldn't vote, women couldn't be on juries. And as far as age restrictions, as long as you were an adult male, which for Illinois at that time was the age of 21. So once you were over the age of 21, you reached your majority and you could serve on a jury.
Okay. Well, thank you.
But yes,
okay.
All white men.
All white men.
All white men. That's a common refrain.
Yeah, indeed. All right. Well, as we wrap up tonight, I'm going to ask, we usually ask a question about Lincoln, but I'm going to ask a Lincoln question, but I'm going to ask one that's more appropriate. And this is, you guys might shoot me later. Okay. So here we go. And you guys will hopefully have different answers. What do you think was Lincoln's best, or what you think was his best case ever? Like, what case did he do, like, that hit it out of the park job, or like that you think he had like the best case? And I'm hoping they're different, but maybe they'll both do the same. I don't know. I did not prepare them, so this is like they're both like Heather.
No, I've got one in mind. If you want me to go first, Sam,
Please.
Okay. All right. So I think the one where he did his best work was the McLean County tax case. That's the case where McLean County tried to assess taxes to the Illinois Central Railroad. The Illinois Central refused to pay it. It goes to the Illinois Supreme Court, and Lincoln effectively argues that the railroad should not pay taxes, which saved it millions of dollars in real estate taxes. And why I think this is, one of Lincoln's most interesting cases, because he's being courted by both sides. I mentioned earlier, if Jacob Hurd had asked Lincoln to be, to represent him, he would have. And again, this railroad tax case is again another example of Lincoln. Oh, he was pro railroad. He was looking forward to the future of the country and railroad transportation, but he was being courted by both sides. But he really had an effective argument in winning the case for the railroad. So I think that was probably his most effective work as a lawyer.
It's a good answer, John. Has immense significance for the future of the state of Illinois. McGinty calls this case Lincoln's greatest case. So that's how he would answer this case. He thinks it has tremendous significance for the future of the country, developing as a society ultimately without slavery. Hard to argue with either one of those, but the case that I go back to in my mind is the Duff Armstrong murder case. Lincoln was involved in about 26 murder cases. It was a small portion of his legal practice. That case, to me, I find interesting because there's so many discrepancies. The historiography is a tangled web. Did Lincoln fake an almanac, or did he use the real one? That's I think an easy question to dismiss. But the drama in it of that closeness that he had with the Armstrong family, that he doesn't forget where he came from. He doesn't forget the people that helped him out when it actually, if they didn't, maybe his life would have turned in a much different direction. You can't argue that he wasn't effective in that case, so effective. But at the end of the day, these cases that have large significance for the future of the country, sometimes we speak with a little too much hyperbole in that direction. Sometimes, maybe, perhaps, but you cannot deny the significance of his ability to save the life of Duff Armstrong. At the end of the day, Duff's neck was on the line in that case. We all probably have our opinions of, did Duff do it or not do it? But did he deserve to die for it? I think that's another question. And Lincoln saves his life. So Duff Armstrong, I bet you believe that was Lincoln's greatest case he ever tried. That's for sure.
You got your wish, Heather. We had different answers.
You had different answers. That's great. It's a great way to wrap up the program. Well, I'd like to thank all of our audience for tuning in tonight. I'd like to thank John and Sam for joining us. And we are actually about to take a break from Looking for Lincoln Conversations until September. So we won't be back until September with a new program, but we hope you will come back and tune in to us then. So with that, I will say good evening and thank you, everyone, for joining us this evening. Night.
Thank you, everyone.